Case 7. U.S. Airways, the plaintiff, versus O'Donnell, the defendant. We find ourselves today in the U.S. Court of Appeals for the 10th Circuit. Starting with the facts. In November 2006, Dana Pabst was a passenger on a U.S. Airways flight departing from Phoenix, Arizona, and arriving in Albuquerque, New Mexico. He allegedly purchased and consumed alcoholic beverages during his U.S. Airways flight. During his drive home from the Albuquerque airport, and approximately 3 hours after deplaning, he caused an automobile accident that resulted in his death and the death of 5 others. An analysis of Pabst's blood drawn after the accident revealed his blood alcohol content was approximately 0.329. After investigating the incident, the FAA declined to take any action against U.S. Airways or its employees. In January 2007, the Alcohol and Gaming Division of the New Mexico Regulation and Licensing Department served U.S. Airways with a citation, asserting that they had served alcohol to an intoxicated person, namely Dana Pabst. The AGD also served U.S. Airways with a cease and desist order, directing them to refrain from selling, serving, and otherwise dispensing, storing, or possessing alcoholic beverages of any kind in the state of New Mexico, without properly complying with the requirements of the New Mexico Liquor Control Act. In February 2007, U.S. Airways applied for a public service license to serve alcoholic beverages to passengers on aircraft in New Mexico. The AGD ultimately declined to issue a license, citing as reasons for the denial the Dana Pabst incident. What was the issue? Did federal law preempt New Mexico's Liquor Control Act's regulation of the alcoholic beverage service on aircraft? Well, here's the holding. While the court concluded that federal law preempted NMLCA's regulation of the alcoholic beverage service on aircraft, its analysis did not end there, but extended to the question whether Part 2 of the 21st Amendment permitted New Mexico's regulatory scheme, as applied to an airline's alcoholic beverage service, to override federal policy. Section 2 of the 21st Amendment provides the transportation or importation into any state for delivery or use therein of intoxicating liquors in violation of the laws thereof is hereby prohibited. Notwithstanding the 21st Amendment's broad grant of power to the states, the federal government plainly retains authority under the Commerce Clause to regulate even interstate commerce in liquor. Let's discuss now the reasoning behind this holding. Let's first look at the New Mexico Liquor Control Act, at what the New Mexico Liquor Control Act regulated. It regulated the sale, service, and public consumption of alcoholic beverages in the state of New Mexico. The law stated, every person selling alcoholic beverages to travelers on airplanes within the state shall secure a public service license. Further, the law prohibited any person from being employed as a server on a licensed premises unless that person obtains within 30 days of employment alcohol server training. U.S. Airways sued, seeking to enjoin New Mexico state officials from enforcing laws that purport to govern U.S. Airways alcoholic beverage service on flights departing from or arriving into New Mexico. U.S. Airways asserted both express and implied preemption in support of its requests for injunction. Specifically, U.S. Airways argued that the enforcement of NMLCA against an airline violated the Supremacy Clause of the United States Constitution, as the ADA expressly preempts state regulation of airline services, including the alcoholic beverage service provided to passengers on flights. Alternatively, U.S. Airways contended that federal law impliedly preempted the application of NMLCA to airlines, as the application of NMLCA to an airline implicates the field of aviation safety, which federal law regulates to the exclusion of state regulation. Further, U.S. Airways asserted that New Mexico's regulatory efforts could not be otherwise authorized pursuant to the 21st Amendment of the U.S. Constitution. In all, the court decided that the New Mexico law implicated the field of aviation safety, as occupied by federal law. Further, New Mexico's regulatory efforts extended beyond the alcoholic beverage service that airlines provide on flights. By requiring airlines to comply with NMLCA, New Mexico was seeking to impose additional training requirements on flight attendants and crew members serving alcoholic beverages on airplanes. However, federal law extensively regulates flight attendant and crew member training programs and certification requirements due to the aviation safety considerations involved. Thus, New Mexico's Liquor Control Act's regulatory scheme implicated the field occupied by federal law. Let's define field preemption and dive down the steps of a field preemption analysis. Field preemption occurs when a state law regulates conduct in a field that Congress intended the federal government to occupy exclusively. Congress's intent for federal law to occupy a field exclusively may be inferred from a scheme of federal regulations so pervasive as to make reasonable the inference that Congress left no room for the states to supplement it, or where an act of Congress touches a field in which the interest is so dominant that the federal system will be assumed to preclude enforcement of state laws on the same subject. When conducting a field preemption analysis, the court must first identify the legislative field that the state law at issue implicates. Having identified the legislative field at issue, the court then evaluated whether Congress intended to occupy the field to the exclusion of the states. Lastly, let's review the purpose of the Federal Aviation Act of 1958. The FAA's purpose is to centralize aviation safety regulation and the comprehensive regulatory scheme promulgated pursuant to the FAA. The FAA was enacted to create a uniform and exclusive system of federal regulation in the field of air safety. Specifically, Congress enacted the FAA in response to a series of fatal crashes between civil and military aircraft operating under separate flight rules. In response to the air safety concerns, the House report discussing the FAA indicated that the administrator of the new Federal Aviation Agency would be given full responsibility and authority for the promulgation and enforcement of safety regulations. Further, as documented in the House report, a letter from a representative of the executive branch to the House Committee on International and Foreign Commerce explained that it is essential that one agency of government and one agency alone be responsible for issuing safety regulations.